Okay, hello, good morning, or rather afternoon. It's 12 p.m. here in Miami, and I guess 5 p.m. in London, right,
5 p.m. in
Janice?
London, yeah.
Wonderful. So let's wait for attendees to join. I believe we have, let's see, 13, 14. Let's give attendees maybe a couple of minutes to join what I strongly believe is going to be a very interesting and practical webinar about, the E-2s under the Trump administration. And yeah, really looking forward to this. And so how's the weather in London today, Janice?
It's raining. It's
London
always been
style.
rainy. It was really, I mean, we usually just have 4 days of a bit of heat and all summer, but we've had a couple weeks. This month it's been really warm for us, and none of us have air conditioning. A lot different than Miami, I think.
Oh, yes. Well, Miami is the coldest city in the United States because of AC.
Yeah. Oh my God.
Yes, it is. So, okay, we have more attendees joining. Let's maybe give more some attendees 1 more minute, and then we'll get started. We do have a hard stop in 1 hour, which would be 1 p.m. in Miami or Eastern time and 6 p.m. in London.
Okay.
So let's see. Okay.
26 people.
Wonderful. Let's see. I would say let's get started. So first thing first, thank you, Janice, for accepting our invitation to do this webinar.
Yeah.
I believe that we've met throughout the years in various conferences, especially the RDC conference in Europe. You will be talking more about that in a minute. And I would like to now share my screen and share with the audience what we have in store today. Let's see the program for today. Here we go. So, okay, so welcome to the Trump 2.0 on the E-2 visa, legal requirements and business strategies for investors. My name is Marco Scanu. I am the founder, and as I like to say, the orchestra conductor of Visa Businessmen. And again, I want to thank Janice Flynn for joining us today. And first of all, I would like to present Janice, and I will let you introduce yourself. Go ahead.
Okay, well, thanks, Marco. I just want to say thanks again for having me. I'm happy, and I love E-2 visas, so so I'm glad to be able to talk about it today. I like you mentioned, I live in London, and I'm coming up to 20 years of living here. I moved under my Irish passport, which I'm very grateful to my grandparents for, and I've been here for 20 years and practicing U.S. visa and nationality law and focusing on the heart of our practice are E-2 visas. We also do corporate immigration, nationality issues, loss and acquisition, and family-based things like that. But I'm originally from Chicago, Illinois, and I was I'm previous executive member of the Rome District chapter, which Marco mentioned. And then I've also been previously on the U.S. Customs and Border Protection National Liaison Committee. And I'm still on the government committee for the coming year for the RDC. So really active, because I think it's been great working with all my colleagues. And we, as Marco, as you see at the conferences, we learn a lot from each other. And yeah, so that's me. That's mainly what we practice. And
Perfect.
yeah.
Thank you, Janice. And let me tell you guys a little bit about myself. Marco Scanu, as I said before, the founder and orchestra conductor of Visa Business Plans. I am also an immigrant. Let me tell you briefly my immigration story and how I ended up in the world of US business immigration. I've been an entrepreneur for more than 35 years, born in Venezuela, half Italian, half Venezuelans. Half Venezuelan, I've lived and studied in both countries. And I also went to college here in the United States. But the most important thing is that I have been an entrepreneur for more than 35 years, launching, growing, and scaling businesses. And I migrated to the US in 2009 under an O1 Extraordinary Ability Visa in business. So I like to say, if you ask my daughter, what's your extraordinary ability? She will say pizza, but that's a different conversation. Now that I then transitioned into an EB1A, also in entrepreneurship. Back then, I guess like many of your clients, all I cared about it was my green card. I didn't know what was going on with my. I mean, I just said, look, I want my green card, and but then throughout the process of going through my case and the fact that the lawyer who handled my O1 decided that she wanted to include a business plan in the O1, that opened my eyes to the need for a very specific type of business plan that had nothing to do with the business plans in the real world. So I learned about the immigration world when it comes to business plans and the difference between the E's and the L's and so on. So I launched Visa Business Plans, and fast forward 16 years, we've done more than 9,000 cases with a key goal in mind, winning cases and helping lawyers get their cases approved. That is the name of the game. I'm not an immigration lawyer, but as I like to say, I am an immigration law nerd. So I attend at least 10 conferences per year to understand what's going on and how different consulates, for example, review cases and review business plans. So we're here to support immigration lawyers and make your life easier. So let's see, what do we have in the agenda today? We're going to be talking about the E-2 visa requirements and processing under Trump. That will be Janice's topic. I will be speaking about business opportunities that align with the current administration's executive orders and the strategic policy objectives. Then we'll be talking about interesting cases study that we worked on together, and then we will open the floor for questions. So Janice, go ahead and
Okay.
enlighten us about E-2 requirements.
Well, I was going to go over initially the general requirements. I've double checked as of today, the Foreign Affairs Manual, which is the guidance for consular officers on E-2 visas. I haven't seen any updates in 2025, so that's how it works. But what we had in Trump 1 was this thing called Buy American, Hire American, which affected e-visas, and it was put into the Foreign Affairs Manual. And it affected probably more the employees, for example, and how that works. But in terms of the general requirements, they're still the same. We have to show that the investor has the nationality of a treaty national country. The company is owned and controlled by that investor, that a substantial investment has been made. So that means there's no specific number, which maybe most of you know, but like there is no specific number that would make our jobs a lot easier. But instead, it's more of an analysis of the nature of the business. How much is required to get it up and running? And what's the proportion that the investor has put towards it? So the FAM, the Foreign Affairs Manual, mentions, difference between, I know they mention a car manufacturing plant, and I always talk about like a PR consultant. Those are the kind of spectrum of companies you might have. And if a PR company, they probably just need a mobile phone or a cell phone to get up and running, maybe. But if they invested even 100%, I don't know, what would you pay for a mobile or a cell phone? And $1,000, $2,000, it's looking at, okay, they've put in 100% of that cost, but is that going to be enough to show that they're going to be serious about what they're doing? And then if you see on the other end of the spectrum, you might have a car manufacturing plant where it indicates, it took $5 million to get up and running, or even to get the doors open, and the investors put in a half half of that amount or 25%, that's still a substantial amount to, they're putting where their money, where their mouth is. And so that's still the case. And what we haven't seen in London and other consular posts is that the amount is changing, because all of the guidance is based on the discretion of the consular officer. But we always want to hedge our bets to, like in London, if we have an investment of $50,000, $75,000, that might be fine. Where other consular posts, it seems like they want to see 100,000. We don't know, but it's looking at specifically the nature of the business. And then, when we moving on from the investment requirement, we have to show the business is real and operating. And Marco, you mentioned that you have heard that something about if the business isn't operating, or if it doesn't seem like it's operating, then that can be an issue. Then I don't see that so much as a Trump issue, but it's always kind of been an issue. And in our firm, we've always been super conservative, and we'd want to show that the business is either operating and is currently doing business, or that once the investor gets to the United States, that it's pretty much ready to get up and running to go. And so that's where, and we haven't seen issues where if we show either of those things, that we haven't had issues with our clients applying for E-2 visas in that way. But it is definitely showing that. And again, it's very specific to the type of business. And this is sometimes where the business plan writer can be very useful, because we're lawyers and we kind of know business, but it's kind of knowing what could we show to get up that the client could have to show that they're about to open their doors and do business, when there might not be doors to open, not physical doors. And then we move on to probably what might be even more confusing maybe than the substantial investment requirement. And this is where especially the business plan is important, is with the issue of whether the business is marginal. So when you have the initial application, the investor's applying for the first time, then you definitely need to have a business plan, because it has to talk about, and Marco, you'll know a lot more about this, but and I know as well, what the embassy wants to see, or the consular post, if it's a consulate or something, they want to know that there is a marketing plan, there is an assessment of the market where the investor wants to do business. There's there's usually a general discussion of what is the business, what is involved with it, what's the executive summary, I guess, and then the projection or projections of profit and loss, which would then demonstrate that. And when it comes to a brand new business, will the business be profitable within 5 years of the creation of the business? And so that it's looking at that. In the old days, it used to be profitability or employment. And that kind of morphed into, instead of into a profitability and employees, because it's profitability of the business, and then technically in the rough terms of what's required is contribution to the community, but it's in effect, how many employees are there? And so when somebody starts from day one, they're not going to have profitability, most likely. It'd be great if they do, but if they don't, then we have that. And then also, if they don't have employees, you have to have a reasonable projection of hiring over the next 5 years. Where if you look at L1 visas, maybe it's only 3 or 1 years, but for e-visas, I want to see projection of 5 years for hiring plans. And working with the investor, the client, to make sure they are directing the business and they understand what they're going to be doing to get it up and running. Because way back when, this is a long time ago, and I think it was a British person, and the exchange rate was 2 to 1, and they invested less, but he had to be able to somebody else wrote his business plan for him, and I quizzed him on it, and he wasn't able to answer the basic questions. And then I told him he had to be able to answer these questions, and and it ended up he was denied because they weren't sure whether he was able to really develop and direct the business. And so that's sometimes like when I was talking about marginality, but that's sometimes when all the requirements for the e-visa start to kind of fit together, where like if he can't talk about his business, he may not be capable of directing and developing the business. And so that's always been the case in terms of the requirements and what's required for the E-2 visa. And I think so that's kind of my introduction, Marco, for the E-2 requirements and the differences with processing under Trump 2.0. I can start to talk about those. Is like I said, we haven't seen that the FAM's changed, but what we're seeing, you mentioned the executive orders, there's all kinds of issues that have come up with that. And then also the major issue we've been seeing is if somebody has any prior arrests, cautions. Well, in the UK, they have this thing called a caution or convictions, that even if somebody under the law, under US immigration law, somebody needs to be actually convicted of the crime in order to be found inadmissible to the US, meaning that they might qualify, it might show that they qualify for the e-visa, but if they're inadmissible, they can't approve the visa, and the person would have to have the consular officer review it for a possible waiver of inadmissibility.
Mm-hmm.
What we're seeing is that the Trump administration's Department of State is now saying if somebody is at risk of causing harm to the US or US society, that the consular officer who, if they approve of an application, and then somebody that maybe has a kind of issue like this, and then that person then does cause problems in the US, then it's going to get back to that consular officer. And that's kind of causing a real issue, and it's making consular officers much more careful before they approve an application. And so that's why at the beginning of a case, it's really important to know the person's whole history to understand, like, make sure they don't have any arrests or convictions, which has always been the case, but it's even more so now, because even in a year ago, if somebody had been just arrested and maybe it's thrown out or then they're not going to be found to be inadmissible, because of the requirement for that is that they were actually convicted of the offense. And even then, if the offense was a controlled substance or drugs offense, or if it was what's called a crime involving moral turpitude, and then DUIs isn't what's called a crime of CIMT, but it can make somebody inadmissible on health grounds. But then again, with this whole harm to US society, which isn't the rule, but like we're finding people with DUIs from 9-10 years ago are being denied. And we don't know if that's actually we kind of do know what's going on, but like that is the major issue that we're seeing. There's I think the main issue, and it's also like consular processing, and then it's I was going to talk a bit about the difference between applying at a US consular post and possibly with the immigration service. So the risks with applying at the US embassy or consulate are possible denial and getting stuck in their country. And so sometimes we may decide to just say, okay, well, you've got your E-2 status in the US. We can apply to extend your stay. It doesn't get you a visa stamp in your passport, but it allows you to remain in the US. And so this happened a lot when we had the financial crash. There were people who we would just tell them, and if, I don't know if everybody knows, but like when you have an E-2 visa in your passport, if you enter the day before it expires, you get another 2-year period of stay. That's still the case. As far as it's under the regulations. Most Customs and Border Protection officers will admit somebody for a 2-year period. So then they have their I-94 record is valid for 2 years, so they can continue to do business. With an extension of stay, it's then asking the immigration service by filing a whole petition with all the kind of documents relating to the requirements I've been talking about to ask them to extend their stay, but it's only for a 2-year period, but it may be enough to do that. So if somebody has these criminal issues, we may have to decide to have them apply in country, but then there are other risks involved with that, where we've been seeing if they seem to be more particular with source of funds, with E-2s that we file with the Immigration Service. So they might be more, so we're kind of drilling in. We always cover that, but it just seems like they're more drilling down into that. And then there's also, they seem to be catching on to these criminal issues or asking for they're making them go for fingerprints. So that's something that we're trying to figure out what's going on, which normally wouldn't be the case, because admissibility shouldn't be reviewed when you're just extending somebody's stay. And then the other issue is that if somebody's petitioned to extend their stay, or if they're changing their status from, say, B visitor visa status to the E visa status, and you're denied, the Trump administration now is doing this thing where you could get what's called a notice to appear, would put you into deportation. And this was in the policy guidelines that came out from the Heritage Foundation in Project 2025. They talked about it, and it seems like it's happening. And then again, it's like, most of our job is trying to figure out what's going on from what we're hearing from each other. So like the conferences Marco was talking about it, and our colleagues and everything is really important, because we may not hear about anything. We may not know what's going on until we can hear it from our friends and colleagues about what's going on. So that's what I've been seeing. And so then it's also being cautious about like being very careful about how you apply it in just applying. I had a client ask me, all right, but what's the easiest way to apply? And there's no one easy way. And if that would be great. I would love that if it was, there was the one easiest way to apply. And I said, they're all complex. They're all we have to be cautious about what we're doing. And before you would decide on whatever strategy, most of the time we need to have them apply at the consular post, because you want to get your visa stamp. And the key, and I don't know what level is everybody on here, but if you apply you have a B visa, for example, most people from Britain or Europe, they could travel under an ESTA, and you can't change your status from that. So you have to apply at your home country, at the US consular post, the embassy or consulate there. But if you do have a B visa and you change your status in the US, you get approved for 2 years. But if you then want a visa stamp in your passport so that you can leave and re-enter on your e-visa, you have to start the process from scratch. And to give you an idea of the timing, in London, you have to file a whole application with the e-visa unit. And they were taking about 4 months, but from what we've been seeing, it seems to be slowing down slightly to maybe 5 months. And so that would be pending for 5 months. And then it takes them that long to review it, and they could either ask for additional evidence, or from that point they'd say just schedule the person in and have an interview, which could be about a month off. So if somebody doesn't apply for that and they leave the country, they could be stuck abroad for maybe 6 months. So it's all these considerations need to be taken when you're going to choose how the person will apply, so that we can best manage it. And it's also, unfortunately, things are changing day by day, it seems like, or hour by hour with the Trump administration and how things are going. And the other thing that I've been conscious of is that you might have seen a few weeks ago that the U.S. Department of State, or maybe it was last week at this point, U.S. Department of State has had a lot of layoffs. They fired a lot of people, and they may be also closing U.S. consular posts. I think, Marco, you're Italian, so I think they were closing like one in Italy, like either Milan or somewhere in there, that they're going to be closing them. But then that affects the overall processing times, and we have to see how all that will play out. But it's something that weighs on our minds to kind of think, well, it may slow things down. I mean, thankfully in London, they've got a big operation, and they're going to stick around, but it's those other kind of smaller posts that we have to keep in mind.
Perfect. Thank you. Can I ask you a couple questions, Janice? As you know, one of the the first question is what's the easiest, right? From clients. The second is what's the ideal investment amount? And again, it depends on the business, and that's also an analysis that we make. But if you were to give a number, like below that number, you don't even feel comfortable doing an E2 case, what would that number be?
I think no matter what, if it's under 50,000, I'd be very cautious. I mean, you can always try to make the argument about like, how is the business? And this is where the business plan can be helpful, but like, if it's under 50,000, we're going to be very cautious because it's also like what could be a factor. Well, these days, especially like most consular posts, if they're a smaller one, like in Dublin or across Europe, there's other in the world, the officers have so much training in visa applications, but if they're not that comfortable with it, they may just think, oh, just it has to be over 100,000, which is why the more the better. And if it is definitely less than 50,000, then we're going to be more cautious. And if it is, it's been a long time since I've heard a lawyer say it, but there's always a lawyer will say, oh, I had a client who spent $25,000 to get up and running and they were approved. And I'm like, that's great. But when you drill down into it, most of the time it's usually because there was a really good argument about, okay, they've only spent 25,000, but the business is likely to make $1 million or whatever it is. It's drilling into the particular argument for the success of the business. So I wish I could tell you, yeah, there's a magic number, but yeah. And so like if the client tells me I only want to spend $25,000, and I'd say, okay, I need to know a lot more before I could even guarantee, or we can't guarantee what, but I always say to the client, we want you to be fairly confident when you're going to the embassy, and none of us like surprises. We want the client to be approved. And so if we're going to do it, we're going to try to complete the application so it's as strong as possible.
Okay.
Yeah.
But by the way, the lowest we ever did was 9,338.
No. Which consular post was that? Can you remember maybe?
Well, no, it was a change of status, but the all the rest, the other elements of the business plan were super strong. I mean, and with
Yes.
very heavy a lot of documents to prove the company was operating. They had, agreements in place with clients that they were bringing revenues already. So it was, but yes, I agree. And, low investment is always a high risk.
But were
And
they already doing business?
excuse me?
Were they already doing business, did you say?
They were already doing business. They bought an existing business, and the
Okay.
business continued its operation. It was a healthy business from a financial perspective, job creation, but more importantly, they had solid agreements in place that would basically the revenue streams into the future were kind of the main client was a super strong S&P 500 company.
Okay.
So, but
Yeah.
again, that's why it was a very unique case. So when clients ask us, and look, unless your attorney is really confident about the case after they analyze every single detail, and second, only if we also feel comfortable, we will work on a low investment case.
Yeah.
Yeah. Now, the other question is, and I think you said this last year that, and I even wrote a post about it, that you say, hey, each U.S. consulate is like its own kingdom, right? They have
Oh,
their
you
own
remember?
post.
Everybody always remembers that. So I guess
Yeah, I was paying attention. So, so question is, other than London, which is where you're based, would you cite any other US consulate where you have seen any very specific or unique or challenging requirements?
We've dealt with Germany, we've dealt with somebody in Italy and Dublin, and Dublin is probably a very tough post. I mean, we had somebody who was grilled the other day for 45 minutes. He was approved, but they were grilled. And so with the exception of London, we're going to be very careful before we send somebody into the consular post, any consular post. And it's getting to your point, Marco, it's like trying to either find out through, like with we haven't dealt with so much with Germany, but what we did is I know a colleague in the States who deals with Germany a lot to kind of find out what's up there and things like that. So that's we try to do that. And then also we're always happy to help people if they've got questions about London and things like that, and
Okay.
Dublin. But it is definitely that's why if a client just says, oh, I just want to file with what we have and just see how it goes, I really don't like that. And I always, well, you're Italian, so and I always I don't want to throw spaghetti at the wall. I don't like
Exactly.
and seeing if it sticks, because it's their lives. And if they apply for it at the US embassy or consulate and they've got an ESTA, if they're denied, they could lose that ESTA. So which I don't know, maybe you've heard about it, but that's why we're also super careful before we'd send somebody in. And I don't like throwing spaghetti at the wall.
Okay.
Probably because I like to eat it, but
there you go. No,
yeah.
definitely one thing that we do tell our clients is, of course, always we're not immigration lawyers, but I know that you don't want to have a denial in your record, because you know how any future visa petition is going to be impacted by that. So it's always good to have a clean record visa.
Yeah, well, and it's not even just, I mean, for future visa applications, it would say, oh, well, you were denied under 214B, but the immediate effect is the ESTA.
Yes.
And it could be lock the person out of the US.
Yeah, definitely.
Yeah.
Perfect. Well, thank you, Janice. Thank you. That was very insightful. Thank you for sharing all of that. Now I'm going to briefly talk about, in we hear and we read a lot of doom and gloom about the Trump administration, denials and so on. But I do believe in always highlighting the opportunities and the good things happening out there. And we keep always track of every single case we work on. We hear from our clients regarding how the visa approval process went and so on. And of course, attending all these conferences and speaking with lawyers allows us to gather always, let's say, market intelligence regarding what's going on out there. And we have actually seen and identified opportunities for big and small investors, in the U.S. aligned with Trump policies and strategic objectives. So some examples include, with light manufacturing, we've done successful cases for, and I'm not talking about huge manufacturing operations, I'm talking about small operations like, let's say, small stuffed pasta manufacturing. So you're talking about spaghetti, Janice. Here we go again with pasta. So pasta manufacturing, again, a small operations. And we've also seen, a couple of cases where clients were importing clothing from, can't remember which countries, but they were doing the final assembly and labeling here in the United States. So again, light manufacturing, I think it's of course aligned with creating jobs in the United States, which is not only again aligned with the marginality concept, but with the objectives. And also we've had a couple of clients work in with their business focus on defense and security. And one of them was a consultant that was going to help the clients fulfill government contracts in that space, defense and security. And also, and I'm sharing the link that I think it's always good to go back and check from the White House, the 8 strategic policy objectives. So any business that is directly or indirectly related to these objectives, I think has a will help us build a good argument in the business plan. And of course, lawyers can help a stronger argument. Technology and innovation is one of them. Anything that helps the U.S. economy, again, economy,
Mhm.
national security, for example, government accountability. So we've seen cases where consultants in government accountability have gotten their pieces approved. Make America healthy, again, healthy food and everything related to and in connection with healthy habits. We've actually done a couple of cases also in this space. So it's again, it's about finding businesses and business models aligned with these objectives and strategic policies. Border immigration. We actually spoke not a long time ago with a consultant who brought a lot of expertise from, I can't remember which country, um, regarding border protection and so on. He ended up deciding not to pursue the visa. He was concerned about, visa policies. I want to put my project on hold, but maybe he will come back and make the decision to move forward. Then we have safe communities, activities and businesses in connection with making communities safer and, social causes. And I know that, E-2 entities have to be for profit. And we've actually consulted with a couple of clients who had very interesting for profit businesses in connection with social causes. So these are the practical examples of cases we've worked on, or conversations with potential clients. And yes, I think that it's important to always keep in mind what are the objectives, what are the policies that can be aligned with our clients' businesses and business models. By the way, I failed to explain, I believe, at the beginning of this webinar that we're going to have a final 10 to 15 minutes for Q&A. I think I saw someone raising their hand, wanted to ask questions, so we will have a space for that in a few minutes. Okay.
And then, oh, Marco, I just wanted to comment on what you just said. And it kind of, I belong to the British American business over here in London. And
Okay.
it kind of, what you were talking about manufacturing is what they were talking about in general. And what the British businesses are doing is that they're going to be focusing more on manufacturing because of Trump's policies, creating US jobs and things like that. So that's all fitting in. And then also what you were talking about in terms of types of businesses and is bringing me back to the national interest exceptions to the COVID bar, where we were focusing on, and we were kind of doing it with Buy American. So it's kind of like underneath the services, Buy American, Hire American, but it's reminded me of us. We have, there's somewhere on, I can't remember if it's Department of Homeland Security, but all the different strategic areas that, and a lot of them are what you have on this panel here, talking about like protection, finance, and then also food manufacturing you were talking about, and then the economy, are all things that are kind of always there, but you talking about this kind of is putting in focus again.
Exactly. Great. Thank you. Thank you for sharing that.
Yeah.
And now we're going to talk about an interesting, a case study. It was a case that we worked on together. And maybe I'll let you, briefly describe the project without, of course, disclosing the client's name or anything, but go ahead, Janice, talk about the case, and I'll talk about the approach that we used in the business plan.
Yeah, so our client, she was an entrepreneur. She's very clever and was, has a couple kind of businesses, but she was going to start sort of a wallpaper kind of interior design area and space. And your Visa business plans were helping with her business plan to organize, she's very creative, and so I think having help with the business plan really helped with this case. And in terms of, I was going to talk about the business plan was really helpful. And so we didn't have any kind of request for evidence. In London, for example, I did mention that we get a request for evidence, but I can't remember the last time we've had a request from evidence from them, knock on wood that we don't, but in terms of I've got a list of the questions that she was asked when she was interviewed. And I think having the business plan helped her kind of focus what she wanted to say and would do, because that's what, when we prep our clients, we ask them to review the business plan and we go through kind of potential questions. But what we've got is the benefit of the actual questions she was asked when she was interviewed. So we've got, she had to wait a long time for the interview. It felt forever, but they were asking why she needed to run her business from the US rather in the UK, because she kind of had it as kind of more of a British brand. So she talked about that. And I'm sure that, I can't remember the whole business plan, but I'm sure that was talked about as well, because you would have had
Yes.
market analysis.
Mhm.
They wanted to know where her stock was, like she was going to sell wallpaper and things like that. Was it in the US? And then I think that goes towards real and operating. Where's your stock? Are you going to be able to sell it? And then she said she had to explain twice about not having a huge amount of stock, and then it just explaining the situation around that. And so we prepared her before that, but thanks, we always like it when she's asked the questions that we've told them they might be asked. And then they wanted to know about staff and how many is she going to employ in the first year, and about office space. And I think and that's again going towards real and operating. And then weirdly, it also asked if she'd ever been arrested. And so she applied now. And so that's why we were thinking there was something going on with these arrest things, because she clearly wasn't. We answered no to that question and things like that. And then she said it was probably 2 minutes, but it felt like forever. But then the officers tapped the computer and said, yeah, you've been approved. But it was all those kind of questions where I think the questions kind of get at where it's first testing the investor to make sure they can direct and develop the business, but also, is it real and operating? Is it going to be more than marginal and profitable and things like that? And so I think the business plan was really, really helpful with getting that off the ground. I think initially it was going to be around 60,000, but in the end it was about 112,000 of investment. And thankfully she was approved, and I'm sure she's going to be a success when she gets there. Or she's already there, so she can do that.
Great to hear. Thank you for the opportunity to help with this case. It really was an interesting one, and I want to briefly touch on one of the things that you just said. The question that they asked, why do you need to be in the States? Which, when we approach a case, that is the first question that we ask. If we feel that our client's business can be run remotely from overseas, then we go, okay, what they might argue. When I say they, it's either the USCIS or the consular officer. They might argue, what do you need the E-2 if you can run this business from overseas? So we actually work with your client to make sure that we clearly explained why she needed to be physically present in the United States. So that was one of the things that I remember. We had a lot of conversations about internally with the team. And the other one was the investment, because her business model is basically she designs all these different, all the different designs ready to go. But when you want to buy one of those designs, you basically go to her website and you purchase the product that she's going to be printing out after you buy the product. So there's no need for inventory really. So we showed a lot of expenses in initial trial runs and products and testing with the different printers, and in the end I believe she had a little bit of inventory. But that was an interesting, very interesting case. So thank you again. Now we're open to questions and answers. Okay, I'm gonna go and see here where. Okay, Q&A.
One question.
So here's a question. You can see the questions, right, Janice?
Yeah. Yeah, there was one about workforce reduction. Could it be a small service provider in agriculture? I think, is that question getting more towards the creation of employment? Possibly. Is it maybe because there wouldn't be available workers?
Yeah.
I think that.
So here's a question. It says, because I'm not sure that all the attendees can read the question. So it says, considering the workforce reduction caused by the massive deportation efforts of the Trump administration, could it be that a small service provider in agricultural zones or hotel areas a viable business plan for an E-2 application? That's the question. So your thoughts are, Janet, that maybe?
It could be viable. I think one of the things we need to talk about is available workers. If that's going to be, because the Domingos mentioned, the person who was asking the question was asking about agricultural zones or touristy, are they going to have US workers available? But I mean, sometimes in your work as writing business plans, do you have to kind of research local labor market that comes up sometimes when we're applying for employees, because one of the factors is if there aren't enough workers, we could have that as a basis. So we've done that sometimes. But when it comes to the E-2 investor application, I haven't seen it yet where this could be an issue where it could result as a denial, for example, if they say that, well, you can't find US workers, which I think is what the question is. If that's a risk, but in the coming months, that could be an issue with what's going on in the US right now, especially in the agricultural zones and the tourist areas.
Okay. So from a business plan perspective, in our view, in our approach, the first line of defense is, the business plan has to be credible and realistic. And, I come from a, business background, and I've been a business consultant for 20 years. So the first question that comes to mind from a business point of view, I'm not even thinking yet about the E-2 requirements. So from a business point of view, so where is this company going to find the workers that these, hotels and agriculture operations cannot find? And how are you going to find them in a way that you're going to charge your clients a fee that they can afford to pay so that they can stay profitable? So that's the first question that I would ask. Does it make sense? And where will you find these workers, right? And how much will you have to pay them? Because of course you cannot pay them under the table. So
exactly.
Yeah.
But Marco, that's been an issue. I had a lot of clients who were based in Florida, and you'd talk to them after they got over in the States, and they said the hardest thing is to find people to do jobs. Exactly. And so I don't know what it's going to be like when there aren't going to be enough qualified workers, because it's like when you employ for proving the jobs that they created when the investors are reapplying, it's not like we do have to indicate for most of the staff the status of the person or something like that, but for all the other workers we wouldn't necessarily have to include it, but yeah, and we have to include evidence of the wages paid. But it was difficult 10 years ago for people in Florida, for example. I know they would always complain that it's so hard to find good staff in Florida, and I didn't know if it was them, but what is it going to be like now when
exactly I think
people working in those industries aren't going to be there to be able to do those jobs?
Yeah, I think generally speaking, it's harder now. And then the other thing is, okay, this type of business is a service-based type of operation. So I'm thinking substantial investment. So it's basically, I guess, either they call it staff augmentation, where you basically hire people and they are under your payroll, and then you have a contract with your clients, and they pay you X amount that you agree on. So the question is, how do you show a substantial investment for the type of business. I mean, we've done it before, but it requires some thinking and strategizing. So yeah, those are the things that come to mind. And we only have 10 more minutes. I'll let you read the next question from Liam. Go ahead,
You,
Janice.
you want me to read it? It says,
Yes, please.
I think it's how do you handle E2 denials, especially if under 214B, without helpful feedback from the interview? It says, reach out to the Consul General, LegalNet, or give it another try, new application after denial, in the hopes of getting a new officer with a different opinion. Okay, so when there is a denial in London and in most other consular posts, the person should be given a letter that indicates why the application was denied. And in London, for example, and I saw one recently that when somebody else had other counsel, or I think they did it on their own in Dublin, they get a letter and it checks the boxes of those either treaty investors, nationality, proof of investment, real and operating, or marginality. They check a box of why it was denied. So we start with that. Did the person get the letter? The next issue is, okay, sit down with your client and get a transcript of, or I've asked clients to give me a transcript of what happened when they applied. So we can kind of try to see between the lines what was going on, what was the issue that they had a problem with. And if there's if it's without helpful feedback, well, you need to get feedback from the client on what happened at the interview. Because if you go to the EV, say you've got the e-visas email in London, email them, they'll say, we made our decision. We gave our client the letter to explain our decision. That's our decision. If you go to the Consul General, they'll probably say the officer made their decision. That's their decision. We agree with it. You're not going to get any information. LegalNet, if you go to LegalNet, you need to have a legal issue to bring to them. So if it's denied under 214B, how are you going to prove that? Because the 214B denial could be for anything. They just think they don't qualify for the visa. What is the legal issue you would bring to them? Other than like, my client should have been approved. That's, so it's I think the key thing is trying to get as much as you can. I've even asked a client to take a deep breath and give us it depends on the client, but and obviously it's stressful when denials happen, but it's finding out what happened at the interview to be able to, and sometimes, with failing that, sometimes I've had to go to the embassy and say, look, we haven't gotten a letter. We don't know why. We have no idea. We try. So we try that, but I think LegalNet, definitely not. You may not get a lot of information from them. The Consul General, and maybe it depends on the size of the post, but I know definitely in London, you're not going to get what you want from them.
Okay.
So somebody's asking, why is it difficult to go through London most of the time? And in my opinion, it's not, because maybe because we're based here. But with London, they've got their particular requirements and how things wants to be filed. And it has to be thoroughly prepared. It has to be well thought out and prepared. And the client needs to be prepped before the interview. So we've assisted people after they've been denied. And one client, and you're helping them with their business plan at the moment, he was denied. He said, oh, we didn't really prepare. We didn't even talk about the interview so much, but the interview is the key bit. And so if the client isn't prepared for the interview, then it's likely it may be denied because the client wasn't ready for it. I mean, they may survive, but I mean, that it's those elements that making sure it's very thoroughly prepared. Sometimes I've seen the application that was filed for the client previously, and it seemed not very well prepared, and it was by a lawyer. It was like, so it's making sure it's very well documented. But the difficulty in London is that we used to have a really good page where they listed everything they want to have, and they indicate what they like. And so, but also, if you're nervous about London, if you write to the e-visas London at state.gov email, and if it's one and you frame the issue for them, you might get some information from them to be able to say, it's not clear from your instructions what you need for marginality, for example, or something like that, before you file the application to be able to. So that helps, I think, with filing in London.
Great, great, great. we've mainly spoken today about E2s, but let me share something with you. I love the E1, and for me is the underutilized visa
Yes,
category.
I
I
do
always
too. I
think,
do too.
I mean, for example, I was checking last year, the trade between the US and the UK was $150 billion. So I'm always thinking a lot of companies and individuals are already qualified for the E1 and didn't even know about it.
Yeah,
So what's your take and experience doing E1s in London?
they've been fun. They've been fine. And but you need to make sure there's enough of trade going back and forth or going from the UK. I always say, think of the ocean and what's coming across from the UK and the money coming back. And what I say about E2s is we can say, okay, looking forward, you can make this investment, you can do this, but with E1s, it's looking behind you and what you've done, how much trade actually exists. So, and then when you, like, so sometimes you say to the client and they don't have any trade, which maybe you've heard as well, but when they
Yes.
do, you could hit the jackpot. And like one time we were kind of like, it was probably 15 years ago where we were kind of languishing with this E2 visa. And the client just kind of offhand, like, this is when I was much younger, and she kind of mentioned, oh yeah, we buy all this from where we kind of, they buy, I realized they had enough trade. And so we just changed gears and we went for the E1 and they were fine. So, but then the E1 can be utilized maybe initially, they can get there under the E. But what happens a lot is that when you may lose the exchange, the trade,
Yeah.
after they've been there for a few years, because in America, everybody wants to deal with an American company. And, we only have a couple minutes left, but, you have to show that there's an international exchange of trade and that it's international in scope. And that maybe after they've been in the States, the investor or the trader has been in the States for a while, they shut down their UK company or their foreign company, then that kind of ends it. They might not qualify, but by that point, they'll qualify for the E2 in that point. So that's why I think sometimes if you think, it's good that you brought this up, because like sometimes people think you're kind of fixed in the E2, but you can kind of switch back and forth according to how it works. And it can be great when you can see, oh, so like the E2 is just not working and we thought it was going to work for the client. And then when you realize there is trade, it gets them over there to be able to do business if it all works, so yeah.
Exactly. And they can actually save, the E2 investor could potentially save a lot of money if they qualify for the one. Last
Definitely.
week we had a call with a client that was referred by a lawyer for an E2, and in the initial call, I heard, hey, but we do a lot of import export, and of course, again, I'm not a lawyer, so I didn't tell the client anything, but I emailed the lawyer, said, look, have you explored, or did the client tell you about this import export, millions of dollars for years? And man, we ended up saving this client $200,000.
Yeah.
They wanted to invest in a restaurant, and
Yeah.
which is fine. We know we do restaurant consulting, so I would have been happy. The same, but I just love the one. And regarding the one last question, we have one more minute. You spoke about existing trade, which is one of the requirements, but the FAM also talks about if there's a contract that calls for the immediate trades that could be used, and we've actually done a few successful cases where the existing trade was actually a binding and solid agreement.
Yeah.
So what's your take on that?
If it exists and we can show exchange of goods and services, so the contract, yeah, if they're bound to it, then that's a bit more concrete than somebody like a brief contract. So it really is dependent on this. Like a lot of times we want to see that trade going back and forth and things like that. But and I can see you're a FAM nerd, maybe, or that's
I
looking at,
am.
my the lawyers who work with me, if they've been with me for a while, but like I would tell them when they first started, look at the FAM and things like that. But But yeah, if you use the FAM guidelines to your advantage and thankfully they had you to be able to say, well, wait a second. And then if you do have the contract and it does meet the requirements, then
Exactly.
possibly the E1 could work.
Exactly. And it
Mhm.
doesn't have to be only products. I mean, we've done interesting cases where the trade was services. An
Yeah.
interesting one was trade of IP between Israel and the United States.
Oh, well,
So
yeah, that makes sense for Israel. They're very big in the tech field. So, I mean,
exactly,
yeah, and it's goods or services. And,
exactly.
the really old case, I think it's from how I learned about E1s was the Italian shoemaker. And so you
Uh-huh,
learn
yes.
about the shoes. So you think that's it, but we've had recruitment companies who were recruiting, and so they were trading with American companies and like that. So we've had recruitment companies, but like it can be anything as long as it's a legal business and it's the exchange of goods or services. So it's like it's just talking to your client and finding out what they're doing. And it is exciting when you discover that you could go with the
Exactly. So we're running out of time. In fact, it's 1 minute past.
why so fast.
It's 1 p.m. Eastern time, 6 p.m. London time. Thank you, Janet. Thank you also, the attendees, the audience. I hope that you get value of the out of this webinar. As always, I learned new things, new stuff. So thank you so much, Janice, and I wish you all a great rest of the day and a great weekend.
Thank you.
Thank you. Bye bye.